Judge Cohen has joined us.
Close those drapes.
All right, we'll go back on the record with Melissa Martinez versus Brandon LeBron. Counsel, you ready to proceed?
Yes, Your Honor. Good
All right.
morning.
Good morning. Do you need more than 5 minutes for rebuttal?
5 minutes should be fine, Your Honor. Thank you. May it please the Court. Jamie Hallscott here on behalf of Appellant Melissa Martinez. We're presenting 3 issues here today, the first of which I think is probably the most straightforward. We're looking at an issue that this Court should review de novo, the concept here of the UCCJEA and its application here. Obviously, this Court has seen many multiple jurisdictional cases, and there's a little bit of nuance to this one.
Well, let's start with the decision out of the New York court. They declined to exercise jurisdiction in May of 2017, correct?
That is correct.
And I know that your client moved for rehearing, but that was denied. But there was never an appeal taken from that, was there?
There actually was a pending appeal. There's a separate law firm that was handling that up in New York. We had been coordinating with.
Is that in the record anywhere?
It is not. Does not show up in the Florida record. No, Your Honor.
All right. Well, then it's for our consideration. It didn't occur.
Well, just simply because Your Honor asked about New York, and it wouldn't.
All right. Then let me ask the question this way: was that order declining to exercise jurisdiction by the New York court ever set aside?
It was not.
Okay. So your argument then is that I think in your brief you state this. You say that New York order is clearly erroneous and should not carry any weight.
It is clearly erroneous and should not carry any weight.
If it was clearly erroneous, then what you do then is you appeal it, and no court has found it to be clearly erroneous.
Well, that's what we're asking. That's what we've asked the court to do, both in Florida and.
You're asking us to find a New York court order to be clearly erroneous.
We are asking for a de novo review of jurisdiction.
You are asking us. That's a yes or no. Are you asking us to find a New York court order clearly erroneous?
Not in so many words, Your Honor. No.
All right. Well, then put it in your words.
Yeah, my words are that the ability to invoke the UCCJEA and place jurisdiction in Florida where it should be, based on the fact that
it should be in Florida.
In New York.
Because we're done. We can stop the oral argument now.
No, Your Honor. It should be in New York based on the information and the evidence that was in the record.
Okay, so I'm going to kind of follow up with what Judge Cohen said. So we have kind of 2 conflicting UCCJEA affidavits, correct?
That's correct.
Because they're very common in family law cases. So the judge is going to look at both and can weigh those between each other. Then we also, on top of that, having a New York court say no jurisdiction, it's in Florida. So between those 2 things, where you have 2 UCCJEA conflicting affidavits, and you have a New York court saying we decline to exercise jurisdiction, what was the Florida court? What was the other option? Where would the home state be if it's not Florida?
It should have been New York. The Florida court should have declined based on.
Why?
Based on the fact that there was not a continuous 6 months here. If you look at.
Where was that evidence?
That evidence was in competing testimony, because Mr. LeBron had his testimony, his one single affidavit. That was basically all the court hung its hat on when it made this decision. It didn't look at travel itineraries. It didn't look at
was that
doctor's
submitted
records.
To the court?
That was entered in the court in the motion.
The court weighed those conflicting testimony.
Not exactly. Okay. The court got those at the motion for rehearing. The court's motion for rehearing was so wholly lacking in reconsideration. It actually only integrated about 1 paragraph. Simply
You're asking the court to rehear something that hadn't been argued during the original?
It wasn't that it hadn't been heard during the original. There was a funeral that happened and witnesses were not able to attend. For those purposes, the court heard those witnesses as well, who were able to speak to this, who were able to testify to these things. Those
are credibility issues, and the trial judge made a determination, found his UCCJEA to be credible, didn't find her testimony to be credible or the testimony of her witnesses to be credible, That's a factual determination that trial courts make all the time.
I don't find that to be wholly credible, Your Honor.
What you find to be wholly credible isn't what's important. What's important is what the trial court found to be credible.
In the motion for rehearing and the subsequent order on the motion for rehearing, it is a wholesale copy and paste, so much that the court was not even aware that I, myself, had been the attorney of record and had been there at the hearing, still referring to the previous attorney as the attorney who had done this, who had conducted the hearing.
That's neither here nor there.
Well, if we're looking at whether or not the substance in this hearing was weighed or not, and whether or not any consideration was given it by the court, you're saying that we should definitely defer to this court, that it had made a ruling based on the evidence in front of it, and I'm saying this was just a rubber stamp of what had already been there, so much that's evidenced by the
Our job is to reweigh the evidence?
A de novo review for UCCJA, yes, that would be appropriate.
Now, would we look at the evidence in the light most favorable to the appellee?
I don't think that you would. I think you would.
So in reviewing factual determinations by the trial court, you want us to take a de novo review of that and to review those facts in the light most favorable to your client. That's the legal position you're taking on this appeal.
The legal position, based on case law, is that it's in the light most favorable to the non-moving party. So obviously it would be the appellee. But what I want, obviously, is that this court look at the facts and the evidence in a way that would be most helpful to my client. I mean, that's my appellate advocacy portion.
That's an honest answer, right?
Whether or not it's supported in the case law is nothing. But I don't. Even if it was in the light most favorable to the appellee, I think the overwhelming evidence in a de novo review supports the appellant's position when it comes to UCCJA here. Are there any other jurisdictional questions? I'm going to move on to the other issues when it comes to time sharing and when it comes to the issues of attorney's fees. When we look at the issue of time sharing in this particular case, the factors that were supposed to be considered by the court do not appear to have been done so in such a way that was anything but punitive.
I know you make that argument. The question for us is, did the court consider the factors in 6113 correct?
I don't see an exhaustive analysis of that on the record, no.
Well, the order says it. The order goes through the factors in 6113.
Have you looked at record pages 848, 849, 850? And that doesn't seem to you to be an analysis of the 6113 factors?
It's a formulaic recantation in order to simply rubber stamp the outcome that I believe the court wanted to get to in this case.
You keep saying that, but as a trial judge, that's what you do. You sit down, or I'm going to tell you, that's what I did, is I would sit down, and I had done these things for years at the time, and whether it was alimony or whether it was the time sharing, you sit down with the statute in front of you and you go through in your order and you tick them off. This is factor, this factor, this factor, and then you make findings. That's what you do because they know, the trial judges know that that's what we look for. And it seems to me that the trial judge did that. Now, you might not agree with...
I'll play devil's advocate, Your Honor. I've been in the opposite position, actually, in having the same discussion with you several months ago on a case, a family law case, that did the exact same thing. I said that, well, the court analyzed these things. The court put all of its factors and did everything like that. And in fact, when I lost that case, you, writing the opinion, explained that the court needed to provide more findings. It needed to have more factual findings. It just couldn't merely say, well, we heard expert testimony and therefore these are the factors that applied. In fact, the same amount of effort that I had to argue conversely last time I was in front of you, you went a different direction. So from a devil's advocate standpoint...
Consistency is the sign of a small mind.
Well, you say, I think, counsel, in your initial brief, that the court failed to afford significant weight to certain time-sharing factors. And I think that's probably where this court is having some difficulty, is that sounds precisely like you're asking us to reweigh. You're saying she didn't put enough weight here, she did put enough weight here, or she looked at this, incorrectly, but that's precisely what case after case has said that we are not to do. So I think that might be where some of the concern is, that it doesn't seem to be an appellate review appropriate.
Well, I think
appellate
the
review
court
of
needs to
that.
look further, Your Honor, needs to look further than that and see that there was an honest issue of whether or not the determinations of the court were punitive in this case. As someone who was there partially for the proceedings, watching these things, there was a great dislike of the appellant.
What if the trial court believed that your client went, as articulated in the order, went to great lengths to restrict and to make time sharing as difficult as possible? What's wrong with being punitive about someone who does that?
Well, I don't think that there's any case law that supports punishing someone. This is for the best interest of the child. When we look at time sharing and
isn't the first factor that a court considers which parent's going to allow the other parent to have a continuing, ongoing relationship?
That is one of the factors, but the facts in this case do not support any kind of finding that would indicate that that was not the case.
Well, I'm not sure that that's true. That there's an abundant facts in this record that she effectively made it as difficult as possible. And I'm not saying that he's a great work of art either, but there's certainly evidence in this record, in the light most favorable to the appellee, that she went way out of her way to make it as difficult as possible for him to see this child.
I don't believe that at all. I've looked at the record.
Right.
I think that there's
The record's
there's some
replete
evidence.
with he goes up there on a visit and has to wait hours and hours. He's ready to go up on a visit that he's already sent her the itinerary. He's going up to New York. She's in Tampa. I mean, come on. How can you say there's no evidence in the record that she was making it very difficult for him to have
That's one
a
example,
relationship
Your
with
Honor.
his child?
I mean, if you want to take one example in a vacuum, then we could do the same thing and analyze Mr. LeBron's behavior under that same standard. I think we're looking at the totality here.
Right, but that's what the trial court does. The trial court analyzes those things,
In a totality.
not us. And again, it was the trial court's job to look at all of those factors. I mean, there was evidence of alienation, no, undoubtedly. How serious that was, and that's the weight the trial court gave to it. So I'm having a difficult time wanting to know where the error is that we are to correct here.
The error is between the evidence and then how it ended up on paper, what it looked like, how the factors actually showed up on paper. Because if the court has considered many, many different things and then just has a rubber stamp type of order that really doesn't do much other than, a recantation of what the factors are, there's not really, that analysis is missing. And that analysis also prevents appellate review in some cases, which is.
Are you saying there's not competent, substantial evidence to sustain the trial court's findings in this
I would
case?
say that there's not competent, substantial evidence.
So on the stability thing, the trial judge got it wrong. Mom wasn't living in a shelter and dad had an apartment. That's just totally, there's no evidence of that.
There's no evidence in the record. No, the record evidence, there was discussions of that, but the record evidence is wholly inconsistent. So that the trial court should have been aware that that was not the case. If you've looked at the testimony of all of the various different parties in the record evidence, it doesn't support that finding.
Right. Let me turn to your legal position that in order to modify a temporary time-sharing order, that you have to establish a substantial change of circumstances. Give me a case that says that. Give me your best case for that proposition.
Best case for that proposition. I can only go with what I had cited in the brief.
I know, but that's not going to do you much good because I've read every case that you cited in your brief, and not one of them dealt with a situation where it was a trial judge going from a temporary order to a final judgment. Every one of them were either post-judgment cases. One of them was a contempt action where there had been no pleadings for modification. And so I'm struggling to find case law to support your legal assertion. Plus, I don't know why the Riddle case, are you familiar with the Riddle case out of the Fourth?
Yes, Your Honor.
Why isn't that case on point against you on that issue?
Well, I know that the appellee is cited to Riddle in their answer, I mean, it's not terrible case law. I mean, obviously, we want to find things that are perfect that fit our positions. Sometimes there's just not a perfect case that fits your position exactly the way that you want it to.
Okay, but I'm trying to figure out where you're coming up with that legal standard. That's the law according to you. If you had your druthers, that's what the law would be.
It's my interpretation of those various different cases that I've cited in the.
So you want us to find that a temporary time-sharing plan could only be modified upon the finding of a substantial involuntary change of circumstances?
I don't think only on that. I mean, we're hanging this on one of the weakest positions, I think, in my entire brief. Obviously, there's much stronger issues here. We're talking about things like the.
You raised it. If you raise it, we're going to.
I try and raise everything that I think I have a
Okay.
colorable argument of law, Your Honor. If I don't, then I end up on the wrong side of any number of different things.
Okay.
But if I have a colorable argument and I think I can make a good faith argument for my client, I do so.
Okay.
You are into your rebuttal time, just to let you know,
Right,
if
thank
you
you.
want to save any time.
I will save that for rebuttal. Thank you, Your Honors.
May it please the court. My name is Nick Shanine, and I represent the appellee, Mr. Brandon LeBron. As the court stated, he's not a work of art. The mother of the child, clearly not a work of art. These are two youthful individuals who have both demonstrated the love of a child, but acted in ways that did not necessarily always work out in the best interest of that child. This judge had to listen to all of the evidence, including the additional evidence that she heard on rehearing, and weigh each of those factors that we talked about. And it's an interesting idea that the accusation, if you will, that what she performed then was a rubber stamp of an order. If any order I've ever read is not a rubber stamp, it's the order in this case. It is absolutely clear, reading that order, that she listened attentively to all of the testimony, that she was very familiar with the facts of the case, and she was absolutely in the best position, in accordance with the case law of this district and every other, that she's the one who gets to make the findings of fact and determine issues of credibility.
Now, Judge Murphy originally was the judge on the case, and did he have a conversation with the judge in New York on jurisdiction?
It's my understanding that he tried to, at least, that there were communications with the New York court, and obviously New York didn't accept jurisdiction the first time. They moved for rehearing. They didn't accept it the second time. If there is an appeal, it's not in this record, and I'll say this, that decision was from May of 2017. We're late in 2019, and we don't have a single shred of evidence in our record to say that any appellate court is still reviewing this. It's crystal clear from our record that New York wanted nothing to do with this case. And so if anyone was going to meet justice for this child and make sure that a parenting plan and time-sharing structure was implemented, it was left to Florida or to no one. Florida said, we'll do it. And then to go back to Your Honor's question about Judge Murphy, Judge Murphy had been in the case before, had entered a temporary order, but as Your Honor pointed out, there is on-point case law, Riddle v. Riddle, that stated, as explained below, a court is not required to find a, quote, substantial change in circumstances, close quote, in order to modify a temporary custody order entered before any final decree has been entered. Here, the judge...
Do you think that Murphy's comments in the temporary order constitute law of the case?
They do not constitute law of the case. Law of the case only occurs once this court has had the opportunity to review a final decision. It doesn't have to come up on appeal if you allow a matter to be resolved and no appeal is taken. It can also become law of the case. Here, temporary orders cannot be law of the case, and there's a really good reason for that. Judges need the ability to be able to revisit prior rulings and to modify them prior to entering their final order. And there's abundant case law that says no matter what that order is, if it's a pre-trial hearing, a judge has to have the ability to make changes. Now, that doesn't mean that parties can ignore pre-trial orders. They do so at their peril. Pre-trial orders can be enforced. And in fact, when they're disobeyed, a judge can certainly take that into account when deciding what's going to happen in the final judgment.
Now, counsel for the appellant states that there's no competent substantial evidence as to interference with your client's custody. What evidence would you cite?
The testimony was replete with instances where there was exactly that type of interference. Judge Edwards referenced those record citations when the former wife would not be there despite him routinely following the court order, the temporary court order, giving her his itinerary well in advance. She would not be at the airport. She might even be in Tampa. She would have her mother come over. And then you have this piece of evidence. You have, there was an explicit video that was sent to him, and that raised the eyebrow of opposing counsel. It raised the eyebrow of the court. Why would she be sending someone who she is accusing of being hostile to her this kind of video? And her admittedly quite honest answer on their testimony was, well, I did it for two reasons. One, to demonstrate that he wasn't all that he thought he was. And then her second answer was, and I did it to goad him. She didn't use the word goad, she used different terminology. I did it to goad him so that he would come up to New York so I could get him arrested. This is not the type of activity that we want parents to engage in if they are going to promote the other parent's ability to have a healthy and nurturing relationship with the child they mutually have created and have brought into this world. The judge was absolutely within her rights and her discretionary authority to make her decisions as a matter of course, and when she did, she went through each of the factors. It was not a rote recitation of factors. She did her job.
Describe it as punitive?
I would not describe it as punitive. That if you look at the time-sharing order, we have two people who reside in different states. There is simply no means by which, if you're going to have a child attend school, for a method to be set up for time-sharing that doesn't involve one parent having a slightly larger or substantially larger amount of the time-sharing. That I have heard of instances where people try to have a child change during the school year. Obviously, there are huge reasons why that would not be in the best interest of a child under most circumstances. So absent that circumstance, there is nothing in this time-sharing agreement that's at all punitive. She gets the child for virtually every single Christmas. She gets the child for every spring break. She gets the summer. She gets this. She gets that. She gets all the things that a parent would expect to get if they are also being included in the nurturing and bonding relationship with the child, but they are in a different state from the child that we're discussing. So the answer to that question is no, Your Honor. This was not a punitive order. This was an order carefully crafted to take into consideration the best interests of the child and to ensure that that child would have appropriate bonding opportunities with both parents.
I know that counsel for the appellant didn't discuss the attorney's fees issue, which isn't obviously the major issue in the case, but would you agree that but for your argument as to preservation of that issue, that it was a deficient order?
That I would admit, yes, Your Honor, that the order should have had an additional clearer finding regarding need and ability to pay. Here, first, the de minimis amount that we're talking about makes it where even the slightest ability or the slightest need makes that order make sense. And the judge did reference in the order the fact that family members were clearly contributing to both parties' ability to litigate this case, and she noted that it was more so on the mother's side than on the father's side where that was occurring. So there is some demonstration of an ability to tap into resources to cover at least such a modest payment. And she even extended, even though we're only talking about $850 or something like that.
820.
820, it gets better. She extended that over payment time. So we had that factor, and then we had the other factor that she noted in the record of her having the ability to live off of the New York benevolent, governmental resources. So there was references. We can find the evidence within the order to support both need and ability to pay of such a small number. But that said, a clearer order certainly would have been better. Here, it's unnecessary because of the preservation issue.
Are you aware of any case law that would allow us to review the legal validity of a New York or out-of-state order under the UCCJA?
Under the UCCJA, under any other type of aspect, the answer to that question is no. That there are instances where Party A contracts with Party B and they both agree Delaware law shall apply. Okay, in that instance, then this court does have to somehow, fortunately we have our computer resources, break out the technology to research and know Delaware law for that purpose. But there is no basis for this court to have the authority to reach across to New York and declare that a New York judicial finding is incorrect on New York law. That cannot happen. There's no case cited to support that proposition. There was merely the bald statement that, oh, you don't have to worry about this because it was clearly erroneous. A, it wasn't, but B, it doesn't matter. That is the finding of the New York court. You can't tell a New York court, we hear you when you say you don't have jurisdiction, but you do and you need to take it. We can't do that. This court has lots of powers. That is not amongst them. So for that reason and the other reasons that I've stated, there is clear support, ample support within the record for the trial judge to have done her duty to patiently listen to all of the evidence and to have clearly crafted an order that is not punitive, that takes the best interest of the child into account, and that fairly meets the opportunity for both parties to participate in and hopefully maturely do their decisions going forward in a way that promotes the best interest of that child that they have raised together. For these reasons, the appellee, Brandon LeBron, respectfully requests this court to affirm the order in all respects. Thank you, Your Honors.
Just very briefly, Your Honors. The counsel for appellee mentioned the explicit video, and I think that was really the core to trial court's determination. When we look at the record evidence and we look at how the trial court responded to that particular video, that's where we see this kind of shift in the court's ability to look at factors in this case. We see the court shift to a punitive nature in that.
I don't know, but there was a back and forth here. I mean, I don't, I give, neither of these parties are going to win Parent of the Year. And there are these emails, and I could tell you that after 200 or so pages of reading those emails, I wanted to hang myself. But it was a back and forth. I mean, she would send pictures, he would respond, and it just seemed to me that was just a back and forth, that they had an on again, off again, let's get back together, no, that it's just they're kids, they're young. I mean, I don't know that video, was the critical feature. What evidence do you have to support that?
The conduct of the court at trial after that particular moment, that was the shock and awe moment to the court, that it couldn't believe that this happened.
Counsel, what is punitive in the order?
In the order, I think that the time sharing specifically should have been a 50-50.
How does that work with two people in two different states? I mean, that's not a normal time sharing when you have two different states.
It could have been done on a multi-week process or a month-to-month as a 50-50.
A child goes to two schools,
But again, you will
It's-
agree
it's-
that that's rare, that it's more common that you have this type. So I'm just trying to figure out where the punitive part comes in.
Well, if we know that the default should be 50-50, and we know we have a challenge with that by splitting it between two different states, and then we look at the relative conducts of the parties in relation, then not only should it have been more for Mr. LeBron, it should have been flipped the other direction and more for Ms. Martinez.
Why?
Because of the conduct of the parties, because of the evidence that was in the record, because of the weight.
But that makes us reweigh, you're asking us to reweigh those determinations in that evidence.
When they're so grossly out of sync, as the record evidence shows, yes, there is some aspect of that to this in looking at it. I mean, yes, this court doesn't review everything de novo, but when there is a determination of credibility of weight that's so lopsided or appears itself to be punitive, then yes, this court can and should be reviewing that for an abuse of discretion. So that's our position, how we see it, and specifically that the issue of punitive nature, I think, is clear from the record. So I have nothing further. Thank you.
Thank you.
Thank you. We'll be in recess then. Thank you.